Thank you very much for joining us today for this webinar. Today, we're going to talk about the effective way that small businesses can get help using the UAE legal framework to help them, collect debts and prevent them to be in that situation in the first place. I'm really happy to be joined to announce we've been joined by Benish Haidar. She's a lawyer and an entrepreneur. So she's been in the legal profession for around 10 years. She's got experience in corporate, commercial, dispute resolution. She holds an LLM in international and comparative law from the University of Singapore. She recently set up and developed and managed a corporate and commercial division at the Legal Group Associates in Dubai. And last year she moved to entrepreneurship and she decided to set up her own legal firm. Amongst other things, they also cater for a lot of SMEs as well. I've known her for about a year or so, and she's always around, for advice. She's really, really helpful from that point of view. She won't bill you for the free advice she gives. So without further ado, Benish, I'll let you take the floor.
Thank you, Rehan. That's very kind of you. Some words that I hope that I can fulfill when I get the free inquiries, hopefully, inshallah. Of course, Rehan has honestly been very kind with the introduction. My name is Benish. I'm the managing partner of a legal consultancy based out of the UAE called Lex Consortia. I'll tell you a bit about the consultancy itself in a while, but about the webinar and the topic, when Rehan and I were speaking about it, what we wanted to achieve out of today was to give out most effective knowledge that will empower business owners, because of course, if you're a business owner, you're already empowered. But in terms of certain processes and certain subjects, some business owners may have certain limited knowledge, which we want to share today. And what I want you to take away from this webinar is not the legalese. I want you to take away practical insight from this webinar. So the idea is to give you the most effective tips, in my experience, that we've seen with clients. How is it that you can handle your debt collection? How is it that you can manage your debts as a corporate? And then give you the best of takeaways that we can. Like Rehan said, without further ado, we will start the webinar. Within the webinar, I'll also introduce myself briefly. The subject of the webinar, like you all know, is debt collection tips for SMEs, particularly within the UAE legal framework. As much as I would say, and being a lawyer, that yes, you can apply these concepts elsewhere in other jurisdictions. However, I will always advise you to consult the relevant lawyer or the relevant expert in each jurisdiction. Lex Consortia is a legal consultancy that was set up a year ago with the idea of sustainability and support to business owners speaking their business jargons. Because when we were setting up the consultancy, we underwent a lot of market research. And what we realized was that we'll have a lot of legal service providers and experts, but not many would put in that effort to relate to business owners. So we go one step ahead and put in that effort to relate to you, to understand your business, to understand your procedures, to understand your operations, and then advise you accordingly. A bit about us. These are the general client sectors. Whenever we're doing a seminar or a webinar, I always say to the attendees that anytime they need any support from these client sectors that we have expertise in, please do let us know. We'll be more than happy to help you out. Some practice areas, of course, part of the practice areas is debt collection. That's why we're speaking about it today. One of the scope of services that we also advise on is debt collection, along with other scope of services, which we can speak about later. Myself, again, Rehan has been very kind. I have 11 years of experience. I have experience in the common law as well as the civil law jurisdictions, and I hold an LLM, and I'm pleased to be supporting you today. Now, basically, what are debts? When, again, you're talking about webinars, you're talking about information sessions, we never go back to the basics. I asked everybody today, what are debts? And I ask everybody to take out a pen and a paper. I do not want this to be a very typical webinar. I genuinely want to try to help out. So if you have a pen and a paper, I want you to take some notes and I want you to answer some questions that we can then discuss in the Q&A. As a corporate and as a business owner, of course, debts have different variations, but as a corporate and a business owner and as an SME owner, there will be some debts that you will owe, and there will be some debts that are owed to you as a corporate. The purpose of this webinar is to focus on the debts owed to you as a corporate and how we can help you streamline those debts. But before we go on to that point, I will give you a personal advice, which is word travels in the market. Always ensure that your own debts are cleared and then go ahead towards collecting them. And this is a very honest advice. You're not here. Yes, of course, UAE is a very transitionary market, but that does not mean that the goodwill and the repute does not stay. So always ensure that your own books are cleared to your own service providers and your own creditors, and then look at your own books. Now take out the pen and the paper and use it. I want you to ask a few things. Have you sat down and have you thought about what is the nature of your business? Of course, you know. The reason I've put trading, because we have worked with a lot of trading SMEs that have faced this issue. So let's say, for example, today, for the purpose of understanding and illustration, we'll use trading SMEs as an example. So understand first, what is the nature of your business? Then, how many service providers do you use? And how many of those service providers use you in reciprocity? So for example, if you use certain service providers, you will owe them debt. But the service providers that use you as well in reciprocity, think about those and classify those, because your dealing with them will be a bit different. And your debt collection with them will be advised differently. Then on the pen and the paper, make a column. How many of corporates purchase from you and how many of individuals purchase from you? Of course, you're all business owners. And the reason that you're here is that you have a standing business. And I'm sure you've done your SOPs and you've done your procedures. But trust me, we've dealt with clients who have not even had a proper customer base. So let alone the bifurcation of their client type. It's very important to understand what your client types are and how many are divided in corporates and how many are divided in individuals, because they will both have different debt collection modes. So bifurcate that within your own system and within your own company. Then my next question to you would be, what is your account and your bookkeeping system? As a lawyer, when you go to a lawyer, if I have to do a very legal session, this can finish in 2 minutes. I can tell you, do a legal notice, go to court and dispute and litigate on it. But that's not the idea. The idea is to make you aware that sometimes debts arise because of a lag within your own system. So I beg of you, sit down first and evaluate your own systems and your own SOPs within your own companies. My question to you is, what is your account and bookkeeping system? What training have you given to your accounts department? What softwares are you using? How automated is your system, even in terms of collection? We have one of the experts who's hosting this, and I'm sure they would agree to this. You can always ask them about this in the Q&A, that accounts and bookkeeping is most essential to any documentation for debts. Because we've had cases that have had to go to courts just because they did not have their proper accounts and bookkeeping, and now it has to be disputed based on witness statements and evidence. But imagine if you had that documentation, you would not have had to go to court. You would have had other modes of resolution for your debt collection. Then my next question to you is, what is your payment cycle? For a lot of trading companies, they work mostly on 3 or 4 payment cycles. One is immediate, which is cash, whether it's individual or it's corporate. And how they classify their clients as well, the size, that makes a lot of difference in how your payment cycle is determined. If you've not thought this through and you're only running as a standard trading company without putting any thought process behind it, then please do put some thought process behind it. What is your payment cycle? Do you do cash only? Do you do short-term credits? Do you do long-term credits? If you do cash only, do you give cash only to all your clients, or do you give cash only to limited type of clients? If you do short-term credit, which type of clients do you give short-term credit to? If you do long-term credit, which type of clients do you do long-term credit to? And then we move on to another essential aspect of documentation, which is, do you retain a customer database? Again, why I'm asking these questions? Because we had, interestingly, in the center of Dubai, a trading company that never retained their customer database. Of course, with the way that UAE is right now and COVID, we are all virtual, which means documentation, processing, and databasing has become more essential. But we still see a lot of SMEs not doing it properly. So ensure that you always retain a customer database. And how do you use that customer database? We will go on to those points, but think of these points, write your notes down, and I hope that a lot of comments that you put in will be practically answered in the next slides. Now, when we think about debts, we always think about that, okay, this person has not paid us for 3 months, 4 months, 6 months, 8 months. We do not realize that debts can actually start arising within our own system, within our own protocols, within our own SOPs. What we do not realize is that the minute we onboard a client, we can have a potential client that will be one of our biggest debtors. So again, this is the next aspect that we want you to think about, which is how do you invoice your clients? Now go back to the payment cycles, which means if you have cash customers, how do you invoice those cash customers? If you have credit customers, how do you invoice your short-term credit customers? And if you have long-term credit customers or corporate customers, how do you invoice your corporate customers? I want you to answer all of these in a bit, and then we can take it from there. What is the payment mode? Do you have LCs? Do you have credits? Do you have payment on delivery? Do you have part payment on payment purchase orders? Once you have your SOPs in place, you will realize that 50% of your debts are minimized. Think about what your follow-up procedure is. You've raised an invoice, you know about your payment cycle, you know about your payment mode. How do you follow up with your clients? Do you just send up emails? Do you have physical follow-ups? Do you have a bifurcation and a hierarchy within your own company for following up? Do you use an external provider to follow up? What you need to realize is in your follow-up procedure, if there is lag, there will also be debt. So the idea for this is for you to understand that debt does not arise when someone stops paying. That also arises because of the lack of relevant procedures within your own system. When is it that you categorize your debt as delayed debt? There is a difference between debt, delayed debt, and defaulted debt or bad debt. So when is it that you categorize your debts as delayed debts? If there are certain debts that are delayed, do you impose some penalty? Do you impose some interest on that? Do you have relevant documents or terms and conditions or contracts in place to impose that penalty on them? This is what we will relate in the future in the next slides as well. And what is your internal and your external action in place? Are you a company that already has certain SOPs in place internally to collect debt, or are you a company that always relies on external providers? Like I said before, my purpose here today is not to push you towards external service providers, to legal service providers or debt collection agencies. My purpose today is give you enough information to have strong internal SOPs to try to minimize utilization of external service providers. How do you evaluate your debts and how do you categorize your bad debts? These are the points that I want you to think about. Why? Because again, debts arise mostly within our own system and later when the debtor is not paying for a few months. When you talk about debts, I've pointed out what debts can be, and I've pointed out the points of contention and when debts can arise. Now, a lot of companies may be at different stages of debt collection, but know that there can always be recourses for your debt collection. I first want to advise you on the internal recourses that we normally sit down with our clients and speak to them. Like I said before, we do not want you to go to an external service provider as a first step. We want to ensure that you within your own system and business have the relevant legal processes in place. I put a question forward. How do you onboard your client? For example, now we have Rehan. Rehan has to become my client. If Rehan gives me an inquiry, do I just onboard him? Or do I evaluate? What is my due diligence on Rehan? Which company is he from? What is his position? Is he even the authorized signatory? Because I can tell you today that a lot of time debts and a huge amount of corporate debts are owed just because the person who signed the contract was not the authorized signatory. So what is my due diligence on Rehan or due diligence on Rehan's company for them to become my client? Undergo and evaluate a due diligence procedure. Again, the time is a bit short, so I want to try to cover everything. If anybody wants to speak about or hear about any aspect in detail, we can always talk about it later. But have a due diligence procedure before onboarding. Yes, sales are the requirement, revenue are the requirement of today, of yesterday, of tomorrow. But if there is a problem and if there is a backflow in your cash flow, then you will suffer. To avoid that, before onboarding the relevant corporates and the relevant clients, please have a due diligence procedure. It can be a small procedure, it can be a lengthy procedure, depending on your type of business, going back to the first slide, depending on your type of client. We as legal service providers also do not have a very lengthy KYC or a lengthy due diligence procedure, but we ensure that we do have. The minute that we are not provided the relevant documentation, that's the first red flag. I can tell you, we get a lot of clients internationally from certain jurisdictions. We get certain clients where we have a detailed KYC, and that is how it is. So sometimes you also have cross-border debts and cross-border transactions. So please think of your due diligence procedure. A lot of times when you've done your due diligence, you move on to the next process, which is the KYC, that now you've decided you're going to take on a client. What is the KYC, which is know your client? What are the documents that you ask from them? Now we have Rehan and Tamsil as panelists right now, sitting there from the same company. If Tamsil contacts me and I know, or I have a doubt that Tamsil may not have the relevant authority, but I've done the due diligence about Alpha Pro partners, I will take them on. But in my KYC, I will ask for the documentation of the manager or of the authorized signatory. If Tamsil is the manager, then I know he's the right person for my debts and for my payments. For the work, it can be someone else. It can be an operations person. It can be a director of any other position. But that is your second layer of onboarding your client. The first is your due diligence, and the second layer is always your KYC, because some clients, some corporates may surpass due diligence, but some may not surpass the KYC. So ask for certain documentation. Not all clients will cooperate, some will cooperate, and that is always a flag. Depends on how much you know that client as well. Once you've done that, and you know what your scope of work is, and an order has been placed with you. For example, if you're a service provider SME or if you're a trading SME, and an order has been placed with you. Again, payment cycle, cash, short-term credit, long-term credit. Let's talk about cash. Okay, you come in, I purchase some goods, and you give me an invoice. What does that invoice say? Does that invoice say I'm a cash customer? I pay immediately. What about the short term? What does that invoice say about the short term, where you have to make me a delivery of, say, 10 cartons? I will place an order with you, you make me a delivery of 10 cartons, and you've issued me an invoice. What if you make the delivery and I don't pay? What if I pay only 25% and I don't pay you the remaining? What are the terms and conditions of your invoice? We have companies, if you look at certain invoices, at the back of those invoices, there's fine print. In those fine prints, there are mostly two columns, and there's a lot of fine print, and there are a lot of extensive clauses. Why are those clauses important? Because someone who's coming into your company to place an order to get a service may not review those terms and conditions at the back of your invoice. But those are the terms and conditions that will protect you. Why? Because those are the terms and conditions. Let's use the example again. If Tamsil is not the authorized signatory of Alpha Pro, I'm so sorry, this Tamsil, but I have to give these examples. If Tamsil is not the authorized signatory of Alpha Pro, behind the terms and conditions, it would be mentioned that whoever is accepting this invoice is the due authorized signatory, which means if it has to go to court and if it has to be disputed, at least this point of contention will not be raised, that whether this person was the authorized signatory or not. What is the process? Do you get the stamps or you don't get the stamps? Do you get the relevant document of the person accepting the invoice? What are your, again, payment cycle? Is the payment cycle mentioned on the invoice? Because for a lot of SMEs, one of the troubles that they face is that their purchaser or their client refuses to accept certain terms which are not written, because initially they will agree. But after that, they will try to prolong it, say, no, we need a 90-day period, we need a 120-day period. But what you may have agreed on was a 60-day period. Have your terms and conditions set up on the invoice. It's only one document that you need, and that is one document that can be printed throughout your invoices. But with that one document, you can genuinely be protected, whether you are a service provider SME or you are a trading SME. Now move on to, this applies to your cash customers as well as this applies to your short-term credits. But what about long-term credits? Recently, I got a call from one of the potential clients saying that they do a lot of deliveries and they give around 3 months to 6 months of long-term credit for those. And for those types of clients and those clients that will give you bulk order, we would advise having certain contracts in place. You can draft those own contracts as well. If you don't want to go to a lawyer, not a problem. But the idea is have the right documentation, please. Because those contracts with the invoice and a particular credit policy in place will again minimize your risk of debt arising. The next aspect will be, okay, now I've placed a purchase order. You've delivered, you're a trading company. What are the receiving documentation? I've accepted it and I tell your driver to go. Is that sufficient? That's sufficient because your goods are out, but that's not sufficient because you've not received your payment. Have you, and trust me on this, we've seen cases which have gone to court with only just one purchase order. That's it. No other documents at all. Which means when you delivered, did your guy take the acceptance of the delivery? Did your guy note down who took the delivery? Did your guy note down which date the delivery was made on, what time the delivery was made on, what location the delivery was made on? We've also seen cases where certain representatives of certain companies have taken deliveries outside and not inside the premises of companies, which means, do you know that this is the right place to deliver? Maybe they may supply it from taking it outside, they may supply it to another place, just because they've been dealing with you and it's a familiar face. So what is your receiving SOP in place and what is your documentation? Which goes the same to the next point, that what are the purchase orders and what are the delivery orders and what are the documents for that you will have. This also applies to contractors and subcontractors. Why? Because we've seen subcontractors as SMEs who also only had purchase orders as documents. And now they have hundreds and thousands of debt owed to them from the big corporates, but they don't have the right documentation. Another advice and another tip that I want to share with you is sometimes you have customers that will give you bulk orders and they don't want to pay. No problem immediately. Or they will pay to you in a long-term credit. Not at all. No problem at all. It suits your business. Take security checks from them. This solution may suit some businesses. This solution may not suit some businesses. But this is a solution that you may not get from everywhere. For example, even if you take a security check of 10,000 dirhams from a client who's placed you an order of 200,000 dirhams, not a problem. Why? And this is very interesting, and I want you to take notes if you want, but there are two things to it. With the security check, if someone is not paying you, with your terms and conditions written behind the invoice, one of the terms should be that you have the right to encash the security check if the payment is delayed for more than 4 months, for example. Number one. Number two, that means it gives you the right to deposit and at least take part payment, because debts will always arise in businesses, but it's our obligation to minimize those debts. And the third and the most interesting is, once you have a security check and with the invoice, if you have that authority and client confirmation to deposit it, if the client does not have sufficient funds, that is okay, you deposit it, it will get bounced and it will automatically give you a right to a criminal remedy against that client. I will speak about possible remedies a bit later because this is not the right time, but I wanted you to know about the significance of security checks. Again, it will apply to certain businesses and certain transactions, and it cannot apply to certain businesses and certain transactions. But of course, this advice has to be given. This is the internal procedure of onboarding and documentation. Once you have that and you've delivered, now the time comes for the payment. What will you do about collection? What is your procedure within your company for collecting? Is it just that one person sitting? That's fine behind the account. But what does that one person do? Which means the day, and again, we have seen delay in trading companies, mostly from themselves, that the accountant forgot to send the invoice or send a reminder on the day that it was due. So please, again, either you use relevant softwares or you automate your system or you create an SOP or you give relevant trainings to your staff. But ensure that timing is of significance for two reasons. One, you need to make sure the day that amount is due, the invoice goes out or a payment reminder goes out, depending on your procedures. Another reason the time is important is that in the UAE, we see a lot of bankruptcy and a lot of litigation and a lot of liquidation of companies. which means that, for example, if your payment was owed 3 months after, what if in those 3 months or the company in the next 1 month is about to be liquidated? That means you need to be amongst the first few to file your claim as a creditor. So ensure that your timing is kept. Another third reason, which some may not know, is that the UAE law allows you an interest rate on delayed penalty up to 12%. Mostly the courts give between 6 to 9%. But this interest starts from the date of the payment incurrence. If your own team has not followed up, that's their default. But if your team at least has followed up and put the invoice or put the payment reminder on the right date, that later claim of interest can also start from that date. My next very practical advice would be that please keep different stages of internal debt collection or internal collection of payment. You may have someone who's doing payment collection. What is your procedure of reminders? To corporates, do you send reminders every 2 weeks? To individuals, you send reminders every 1 week? Bifurcate. Because individuals are most likely to pay you in a lesser time. Corporates are most likely to take a longer time. But follow up, consistently follow up. This follow-up will also help to make your documentation if the client has to become a defaulter. The more the follow-ups, the better. Of course, you don't want your client to run away or you don't want your goodwill to be affected, but please do have certain procedures and an automated procedure in place. That's the purpose of it. Do not harass them, but please have certain procedures in place. Then we move on to the next step. Sometimes clients come to us thinking that they have had full procedures in place, but it stopped at the time of automated, where the automation is written. We sit down with the clients, we ask them, okay, no problem. Have you sent them any official communication or a dunning letter? And they ask us, what is a dunning letter? A dunning letter, search on Google, this will help you. A dunning letter is a financial claim letter that a company makes themselves. We work for a lot of MNCs. We draft their templated dunning letters which they use. Of course, a lawyer can help you draft that, but there's something you can do it yourself as well. Because a dunning letter or an official communication is something, number one, that should be on your letterhead. Number two, that has to mention what the transaction was. Number three, that has to mention the relevant dates. Number four, that has to mention since how long the payment was due, and make that document official for the company on the letterhead, duly signed by the authorized signatory and stamped. Because sometimes certain emails may not have the same impact which an official communicated, delivered, couriered letter by the company will have. And we've seen the differences. So sometimes when we think that the matter is not reached a legal notice stage, we send the client back. We tell them to do a dunning letter, whether we draft it for them or they do it themselves. But that is the time that you do certain official communication, which fulfills these 4 or 5 requirements that we've mentioned to you, and you send out your dunning letter. Certain components of a dunning letter are very, very essential. So please ensure you fulfill those. We can always help you. You can search it. You can do it yourself as well. Once you've sent a dunning letter, then within the dunning letter, you need to give a particular remedial time as well. Because after the remedial time lapses, you need to do a follow-up with a physical visit. Companies do not have these procedures in place. Just by email follow-ups, they think they've done the maximum to minimize their debt. And that's when they look to external service providers. I always say, do more. Do the maximum that you can for your debts and within your own company as well. So you can always go physical visits. Within the physical visits, there's something called a remedial payment notice. That remedial payment notice is a bit more aggressive than a dunning letter. Dunning letter is a standard templated financial claim letter. A payment remedial notice specifically mentions that payment, mentions that we sent you a dunning letter. It is now due. And in that, you mention that if further this payment will be delayed, we will claim interest. So that even if it has to go to court and the delay, you have that written down that you will claim that interest, and it starts running from that point. I can tell you that 30 to 40% of your debts would be minimized by just following this entire internal procedure. Please ensure that you have certain procedures in place internally, and then always external service providers are available. The next slide, of course, talks about external service providers, and I still bring legal as a last recourse. What many lawyers do not share very openly is because, of course, they would want you to come to them, debt collection, easy, they'll file a case, they'll send a legal notice. But you have other recourses externally as well. And I want you to be aware of them, and I want you to have that knowledge. One of the things for debt collection is Dubai Economic Department. If you are a mainland company, or your client is a mainland company, you can reach out to the Dubai Economic Department, file a B2B debt, not a debt collection, file a B2B complaint. What that complaint requires is proof of a contract or an invoice, because what's important is, and we've used it for certain clients and it's not been effective when the client does not have the relevant documents in place. So only approach the Economic Department when you have documents in place, because they're not lawyers. They're only authorities that will be there to help you, but they need that document. So we go back to why documentation is also important for this recourse. It's not only important for your own internal recourses, but it's also important when you go to lawyers, when you go to other authorities, when you use external recourses. You can use the Economic Department. If I'm not wrong, the cost is around 2,000, 2,200 for B2B applications and complaints, where you attach your contract or you attach the relevant invoice, you attach the relevant documents and follow-ups that you've done, and you submit that application, and then the Dubai Economic Department follows up with that client or the customer. This I will give a 20% to, because some clients and some companies, when locals and authorities follow up with them, will seize and make some part payment or will approach you directly. So you have a further mitigation into your debts. Then, of course, you always have debt collection agencies. Why do I say the debt collection agencies come before legal? Because some clients prefer going legal straight away, but some clients prefer going to debt collection agencies because there are certain debt collection agencies that work only on contingency. So they only take from you what has been recovered by them. So explore these debt collection agencies. The only limitation, and of course, every authority has certain limitations and every recourse has certain limitations. The only limitation of debt collection agencies is they don't have a legal right to issue legal notices. So they can only send a payment reminder as a debt collection agency. They can do their follow-ups. All debt collection agencies have their own SOPs. So explore working on with debt collection agencies on contingency, where you're not paying, but they will take their fees out of what they recover for you. So explore that. If that also does not work, you can always explore alternative dispute modes, again, depending on the documentation that you have. Sometimes for certain clients, when we are drafting their contracts or when we are drafting their invoices or their terms and conditions, we put certain alternative dispute modes before legal. So for example, when you read those clauses saying this dispute will be resolved by Dubai courts, in those clauses, we mentioned that this dispute will be resolved between the parties amicably through mediation or through negotiation or through any other mode. We first utilize that mode and then still keep Dubai courts. So depending on what your dispute resolution mode is, explore that as well. Another external solution, which may not be applicable again to all SMEs, is selling your debt. I don't know how much of you may be aware of that, but we've also done transactions where corporates sell their big debts. So they're debt purchase agencies that purchase your debts. They have their requirements. The debt has to be of a certain value. They have to have certain documentation. And you provide all the details of the debtor and you sell your debt to them. That means they pay you, you become debt free, and then it's their responsibility to collect the debt. Sometimes they take their professional fee in a reduced amount. For example, if the debt is 100,000, you give all the debt to them, they pay you 80,000, which means that 20%, whether they recover or they don't recover, is the fees they've charged you. Sometimes they don't do that, they recover the entire 100,000 and you pay them a 10%, whatever is the arrangement between certain debt purchase agencies. There are two documents that you need for debt purchase agencies. The first is the debt selling document between you and the debt purchase agency. And the other is, it is your obligation to inform your debtor that you sold the debt, which means that when someone else is intimating that debtor, again, for example, Alpha Pro has sold their debt to Legal cannot do that, but for example, to Lex Consortia, and Lex Consortia is approaching a third company, ABC Limited, that we are reaching out to you to collect this debt for us, not on behalf. We're not a debt collection agency. We're a debt purchase. We've purchased this debt. So now you are our debtor, which means if we have to take you to court, ABC Limited, Lex will take them to court. We've paid Alpha Pro as a debt purchase agency. But Alpha Pro is required to have a contract between them and us, and they're required to inform their debtor that the debt has been sold. This is the name of the company that will purchase the debt, and they will contact you accordingly, so that the debtor cooperates with them, and that there was due information and due process and due knowledge for the debtor, so that even if it goes to court, Alpha Pro would have done their part. Once you've explored all of these, some may be applicable in certain cases, some may not be applicable in certain cases. That's when you go legal. When you go legal, you have 3 types of legal modes of resolution. The first are legal notices. Depending on the debt amount, depending on how much internal recourses you've done, if we know that the official communication has been so strong with your debtor, we will actually cross the point of a legal notice, and not we, meaning that's what we will genuinely advise our clients. And we will tell them, okay, you know what, better to litigate straight away, number 1. Or number 2, if we think that there's still that gap of legal notice, whereby following the entire internal procedures, you've reduced your possible debts to 50%. And then by proceeding your external procedures, you've reduced it 20%. Legal notices have a bracket of 20% as well, where when the debtor gets a legal notice from a firm, in the legal jargon, they tend to cooperate. We've had cases recently that we've handled for SMEs from between 500,000 to $1 million as well, that's only been resolved by legal notices. So sometimes legal notices are the most crucial, but sometimes when we believe that the documentation is strong enough and aggressive enough, that a legal notice will not also help you achieve the same, or the amount is too small that you pay separately for a notice, we'll advise clients to go to court straight away. A legal notice can result in either a settlement, or again, it can result in no response. If it results in no response, it has to go to court. If it results in a settlement, always ensure 2 things: that you have a settlement agreement if the amount, of course, is big, and you have PDCs that you've taken for the amounts and the payment schedule that you are settling for. Again, for example, a payment of 100,000 to be paid in 6 months at 20, 20, 20 each, or whatever. I'm so sorry, the maths is. I'm a lawyer, so no maths for me, but have PDCs for that. Why? Because when the time comes and the debtor has not paid you, you deposit the PDC, it bounces, you get a criminal right, which means debt is normally a civil remedy. When you go to court, you file a civil case. But whenever you've had a security check or a PDC bounce, you will get a criminal right. That means you have 2 recourses in court also. You have a civil recourse as well as you have a criminal recourse. Now, we've done everything and we've still come to court. Court will look at 2-3 cases. Depends on how contentious or non-contentious your matter is and how small or how big it is. Everything that I've explained and spoken about can also help you at the court stage. Because, for example, you've not been able to collect your debt with all the recourses we've discussed, internal or external, but at least the documentation can help your court case. Because wherever the documentation is weak, either courts take longer or they do not do full justice to your debt. But wherever your documentation is right, it will become a very basic, very easy, straight case, and it will be awarded to you again where the documentation is proper. Another thing that sometimes is not advised to is about the execution. Sometimes certain companies are liquidated or they don't have the relevant funds. That means go back to the first point that I mentioned, due diligence. If you know, again, Alpha Pro has sufficient strength in the market, that means executing a case against them. Please do not do that. Rehan is the host of that. But executing certain cases against a particular company that you've done due diligence for, you know that there are assets in the market. So your execution and your court judgment will also be effective. Because sometimes lawyer will just say, we will file the case, but they will not advise you that sometimes it is not easy to execute because the other company does not have the funds. So explore that as well and ask your lawyer these questions. I've mentioned cross-border transactions. I covered it very briefly, but it's a completely separate topic. All these documentation will also help you in cross-border transaction. But the one advice that I'll give you right now is think very carefully what contract, what dispute resolution mode and governing law you put in for cross-border transactions. And always file for debt collection a case at the place of the debtor, because that's where his assets mostly will be. Okay, that's the brief advice that I can give you because we're really short of time. Can debts be prevented? One thing is important to be understood, and you're all business owners. Wherever there is business, there will always be debts. But we do not think about documentation. We do not think about SOPs. We do not think about how essential the timing is. We only realize that a debt is accrued since if it's been a few months. Please focus on your documentation, your due diligence, your KYC, your invoicing, your accounts bookkeeping, your follow-up documentation, strong internal procedures and protocols. One point that I did not cover in the previous slides, which is here, is the stay on mind mechanism. This is very interesting and it's all psychological. And it's weird that a lawyer is saying it, but we've seen it work. Sometimes when you have that client database and you approach your client for another thing, for example, again, like a webinar or a newsletter or another information session, there is a stronger chance of staying connected, thus a stronger chance of getting your receivables, or at least part, or at least that open channel will be there. So it's a very practical point that I'm raising here, and I hope everybody can understand it. But it is a stay on mind mechanism. If you only have that relation where you just send payment reminders, someone will step back. But if you have another relation where the channel is open to different employees of your company, or there's a database that you use for greetings, for newsletters, for subscribers, for any other information, channels will remain open. And I'll tell you what, we've even seen it with legal consultancies, where we send out, I'm sure you must have all been subscribed to legal consultancies. Certain newsletters go out, certain legal updates go out. If a particular amount is owed to a legal consultancy and someone else is interested in a second service, they will come back. That's an example of any other service industry. So it's a very practical example that I'm giving, but try to utilize that. Make a database and use it for different purposes. What are your legal rights? I want you to understand, particularly why, because it was mentioned in the brief of the webinar, debt collection is your legal right. The fact that you're running after your money, you are not on the wrong side. It may seem tedious at some point, and you may start rethinking whether it's worth it. Every penny is worth it. And whenever someone comes to us and tells us that even if it's an amount of 10,000 dirhams, is it worth it? We tell them if you get the right amount of fees from a lawyer or you use the right recourses, every penny is worth it, because you will also get interest on delayed payment. So do not forget that if you are litigated. Collecting your debt is your right. Going legal is your right. If you have the right contract and terms and conditions in place, that means it will also become your contractual right, not only your legal right, because you've mentioned it in the terms and conditions and the contract. Interest on delayed payment is also your right if you're litigating it. Settling or giving certain reductions is a right. Compensation is your right if, for example, I'll give you another example, where you've had, you were owed 100,000, and the 100,000 was very crucial to a certain transaction that you had to make for the company, and you were held back from that transaction. That means you incurred a damage or you lost an opportunity which was provable. You can get compensation for that, provided it's a very legal route. You have the right documentation and evidence for that. Civil and criminal remedies, I've already spoken to you about that. Checks will give you criminal, normal debt collection and contracts will give you a civil right. How do you find the right lawyer? Please, whether it's me or anyone, or you consider any agency also, it applies the same. Sit with the person who is willing to understand your company's procedures. Because if you have a debt one place, you have a debt in another place. If they look at just your debt and what they can make out of it, that means they're not the right representative for you. They should ask you your operations. They should ask you the nature of the claim. They should ask you what you know about that debtor. They should evaluate the degree of the breach from the debtor, whether that debtor has part paid or completely defaulted. If that debtor is part paid, their approach should be a bit different. If that debtor is completely defaulted since 9 months, then yes, their approach should be straight away litigation. And ask your lawyers about the execution as well. Please, these are certain aspects that not many people are aware of. When you sit down with your service providers, ask them, because it is your right to ask them. You are the ones who are going to be paying them, so be aware of your rights. Normally, we'll give tips and advices which are practical. I've tried to cover up mostly practical and non-legal advices, but one thing that I'll always tell you is you have a debt, but try to preempt it by the documentation, by the SOPs that you have. Try to prevent it by trying to minimize it and settling, and then only go to other recourses, whether you litigate or you go to any other external recourses. Any other questions or answers, anything that I can do to help anyone, please let me know. Of course, you can get my details from Rehan. They will circulate it out as well if anyone needs it. If otherwise, you can always hold up your phone. This is the QR code. You can scan it and you'll get my details. You can always contact me straight away as well. Not a problem. Thank you very much. It's been a pleasure. And I'm so sorry if this was overtime.
No, Benish, thank you very much for your insights and for your advice. I mean, I'm sure everyone who's attended has learned a lot from it. Yes, so I think we'll now open up the floor for a few questions. Now, during the session, there was a few questions that propped up, so I'm just going to fire them at you. We had one person, Saeed Riyaz, saying how to check the background of any individual. We have lots of individuals.
Okay, so number one, investigation against an individual is illegal in the UAE. So please do not do that. What you can do is you can take certain documentation from them. Once you have their passport, you are aware whether they're registered or not, or they have a visa or not. A lot of, again, depending on the company that you have, a lot of customers coming in don't even have the right visa. When you collect the relevant documentation, what you will realize is certain documentation does not even reconcile within them. For example, they're telling you that they are coming from a particular company, even as an individual, but their visa is sponsored by someone else, or they've purchased through someone else. And when you ask them for their addresses and you actually go, you don't need to physically go in or investigate legally, but you can always go because they've given you their address. You can go to that locality and check, and you don't see that that address is there as well. These are small practical things. Again, try your best to find out. For corporates, you can always do due diligence as well. There are companies that do it. There are legal service providers that do it. There are certain companies who have enough resources and manpower that they can do their own due diligence themselves as well. For a lot of cross-border transactions, we do corporate due diligence and legal due diligence, but those transactions are very high in amount. And because they're cross-border, it's very important. You don't know who's sitting in which country. So you approach a due diligence provider or a legal provider to run a formal due diligence on them. It was very interesting. We got an inquiry once. Someone was taking, it was a loan facility provider. And they were taking a loan or being granted a loan by this facility provider in the UAE for a few millions. Once we ended up doing diligence on the UAE company, we advised our client not to take the loan, because this company turned out was known to create SPVs, which are special purpose vehicles, to grant loans. And in the end, they never ended up paying. And they used to take upfront fee for actually granting those loans. So that diligence, a few thousands, to a legal service provider or a diligence provider, preempted our client from the big loss that they had to incur. So I hope that's answered your question.
Okay, thank you very much. I've got another question from Rahul. How to recover your funds if there is no contract or deed of trust signed, but we only have issued invoices?
Do the invoices have terms and conditions? Again, we've seen mostly do not for SMEs. So in that case, you will have to straight away, if you've done your internal recourses, now I've explained to you what your internal recourses would be. Have you only followed up by emails or phone calls? Document your phone calls as well. Do not record them. That is illegal. Recording without consent is illegal. Please know that. But document it. Physically go to their site or to their company. Ensure after each physical visit an email goes out so that that physical visit is also documented. If you've done and followed through the entire internal recourses that we've discussed today, then try to approach depending on their license, you can explore Dubai Economic Department, you can approach a debt collection agency, or you can then approach a litigation company just because you don't have the relevant documentation.
Thank you very much. I've got another question from James. Can DED also be an authority overlate invoices in other Emirates and other GCC member countries? Is there a maximum or minimum size of invoices when speaking to the DED?
If I'm not wrong, no maximum or minimum, but please check, because again, like we all know, everything keeps on changing day to day with the authority. So I don't want to be wrong here if I quote anything. That's why I also said, while I know their fees is 2,000, but I said almost 2,000, 2,200 because it can change anytime. But it is only applicable to mainland companies and within the UAE. Okay. Actually, within Dubai only, because it's Dubai.
Thank you very much. I've got another question from Raju. Hi, Raju. How do you use economic department for B2B complaint against a free zone company? So we're a free zone company.
No, you cannot.
Okay. I've got another one from Ranim. Warning letter is issued by the lawyer or the company?
Company and lawyer, and company and or lawyer. Which
Okay.
means the company can also issue it. If a company issues it, I always say it's better. Why? It's very interesting. Because if you've done your follow-ups and you've done your official communication, that means when you come to us, if honestly you have the right lawyer, the lawyer will actually evaluate and see what responses they gave and then draft the next document and not do a standard payment notice, but strategize according to the responses you've received.
Thank you very much. Another question from Rahul. For future customers, which document shall I make client sign along with the invoices? He's mentioned his industry is events. So which document should he get the client to sign?
So for events, there should be a contract for sure. So the invoice should have the terms and conditions, but the contract for events should be for sure, because you can have small events, you can have big events, you can have events of series. So it depends if you have, say, for example, corporates that are your retainers for your events. That'll be a different, like a long-term credit concept. So you'll have a different retainership agreement, for, if I'm not wrong. And then for immediate events, I can sign you up for an event, or someone else can sign you. You should have a contract in place, because events also, depending on the service that you are giving, you will also have a lot of physical assets at the event premises. So what if there's a damage to that? There's no damage. What is the liability? What is not the liability? What is the nature of the event? So I would strongly suggest do a contract with them. Thank you very much.
Saeed has asked a question. Do debt collection from individuals is the same? So I think what she's saying is it the same? So you mentioned the process in terms of when it's a company, right? So if it's an individual and you've rendered a service to them, you obviously can't go to the office. So would you go to the home? How would the kind of process differ if it was an individual as opposed to a company?
I've given insights on both. So for example, if it's an individual, then again, you do the same follow-ups. You just use their address as whatever address they've given you in the KYC, or whatever address that you've acquired now that you don't have a KYC yet and you are yet to incorporate it in your procedures. Then whatever address you have, that address is used as the address for the notices, for the payments, and of course, within the emails and the physical follow-ups as well. You are allowed to go collect your money, but you're not allowed to harass them, of course, and particularly individuals, because there is a privacy law as well. And if those individuals represent companies, then try using the corporate addresses.
Thank you very much. Is there any, I'm sure there's lots of questions.
Rehan, I think we're getting some questions on the chat instead of the Q&A.
Yeah. I'm going to unmute Manoj.
Yeah, and there were some questions over there as well. I think so. Anna had some question about the name of the letter that Binish had mentioned when she was taking the presentation. Now, I do not know which. If Anna is there, I mean, if we could allow her to speak and ask her question.
I think we can do raise hands if that's okay with everybody.
If you want to raise hands, I can then allow you. Manoj, do you want to ask your question?
Manoj, I actually made a specific note for you because I know your case specifically, but you ask and I will also come back to you about an advice that I have for you.
Yeah, based on what I was going through your presentation, one of the things that you mentioned that if they are accepting the goods within their own vicinity, like within their own shop. Now, I am into hotel and restaurant supplies. So what the restaurants do is that they have a storage room which is quite far away from the actual restaurant itself.
Hmm.
They've bought a separate storage facility in some other building rather than where their restaurant is. So
Hmm.
when my guys go and deliver, they go and deliver to that particular storage section, and the guy signs it over there itself and gives the paper back to us.
Hmm. Hmm.
So in terms of when you mentioned that
Hmm.
we need to give the we need to understand that where we are giving the goods, what time, what place, where exactly within their restaurant or not. So how do we cater to that?
So if you do restaurants, or if you do hotels, or if you do certain management companies, they will always have that set delivery point, that because they've most likely leased that point, or they own that parking area, or wherever the delivery point is. That's when you mention it in your T&C or in your contract. There are two things that you can mention. If you want to be very specific with the big corporate that you're entering into a contract with, then you mention that the delivery point shall be prescribed to be this, and you mention, like how you mention the address of the party, that I'm entering into a contract with this party addressed at this. You mention the contractual delivery point so that you can hold them liable at any time the contractual delivery point is not the same. But in your case, if you do not have a contract, in the terms and conditions, you mention that the delivery point prescribed or communicated by the representatives of the company is what the delivery point shall be for the purpose of the delivery of the goods, and respected and obliged by between the company and the service provider, which means that delivery point is what the company will have to agree to, because it will be part of the terms and conditions.
Yeah, okay, fine. But that keeps on changing, because most of the time, even though they don't have a delivery warehouse or something, they sometimes even store it within their staff accommodation. So
They
I
do.
can't
They do.
all those points as well.
That's fine, which is why I said mention that whatever delivery point is mentioned by their representatives. So in the terms and conditions, do not mention the address.
All right.
The contract, I said, for example, if you go to any hotel, like you go to the Marriott, in their parking, mostly the loading bay, or they'll have a delivery. For such contract or corporates, the delivery point mostly will be fixed. But in
Yeah,
your case,
because
have
yeah,
the terms and conditions.
loading area also have the cameras and everything. So for
Yes.
hotels, I'm completely fine. But in terms of restaurants, is where
So
the
that's where you put a statement saying that whatever loading point is mentioned by the representatives is what the company will also adhere to.
all right. And just one more point on the due diligence. In terms of due diligence, when we sit down with the purchase managers, although they are not the authorized signatories, the checks are always signed by the owners. So in order for us, in terms of documentation, the best that we can collect is trade license, the VAT certificate, and the passport copy of the owners. But the people whom I keep on communicating with are only purchase managers who keep on changing in a year's time or 2 years' time. So they are never an authorized signatory. So when I'm doing my due diligence, I'm failing on the first part itself, where I'm not getting any documentation from the authorized signatory.
There are two things. Number one, the fact that you get the documents of the company is more than enough right now, because when you file a case for debt, you will not file it on the purchase manager, you'll file it on the company. So sometimes we even struggle filing cases because companies have not taken the documents of their debtor basic documents. That's the first part. So that's sufficient. The second part, in terms of who you're dealing with, is where the terms and condition come in, that whoever is being represented or nominated by the company to be your procurement manager or account manager is confirmed to have the authorized signature. We've had so many cases that mention, just because the authorized signature was not the authorized signature of the company and there were no documents to prove that, their debt or certain documentation was not acknowledged, which is why authorized signature is important, which is why terms and condition mentioning that the person nominated to be your procurement manager is the authorized signature, which means not every time the procurement manager, when they change, you need any documents, because you have a standard term that they have accepted to.
Okay, sorry, I don't want to take much of a time, but just one last thing.
It's okay, though you are Manoj. I know you personally, so I can joke with you. That's fine, but go ahead.
I've gone through a debt collection company myself. Now, the problem that I face is that, irrespective of the amount, initially they say that they would do a recovery for you and they will charge you a particular percentage based on recoveries, which is fine. I'm okay with that. but then that percentage keeps on varies between 12 to 15%. Now, after that, with certain companies, even though the companies say that we are still not going ahead and giving you a payment, so I end up paying for a 6 to 8% of a letter that they issue towards the company, saying that this is the amount of debts that you hold. And secondly, once they file that case into the court, and the court says that if the person does not show up in the court, they give 3 chances. I guess that's what they had come back to me. There were 3 chances given, and the restaurant guy did not show up. And then afterwards, all the judge advised was you can go into a civil case mode. So if my amount is small, say around a 35 to a 50,000 ticket, I pay up 6%, 6 to 8% for the letter that is being issued to the company. And then if I want to again go to a civil case, I have to pay an additional 8 to 10%. So if you understand, from a 30,000, if I'm paying almost 20% in terms of just court fees and everything apart from the lawyer fees, am I in a position where even if I recover that money, I'm actually losing much more than that?
Okay. Number one, because I know your case, particularly myself, you did not go to a debt collection agency, you went to a law firm.
Okay.
So then number two, there are certain debt collection agencies that work again only on contingency. That means that the initial amount that you pay them is a bit different in terms of the structure. And number three, fortunately or unfortunately, and that was the purpose of the session, to try to make everybody aware and knowledgeable of the possible steps they can take before it goes to court. So once it does go to court, every creditor has to pay lawyer fees and every creditor has to pay court fees. So before it goes to that, and that's why I said that I have a second solution for you, which is a debt collection company that will now only charge you on contingency and not take any upfront. I know of someone and I'll introduce you personally to them.
So basically, we have to even do a due diligence on the debt collection company as well.
Really, I would say in any case, like any service provider, don't go to a random service provider, please.
How do we do a due diligence on a debt collection company? How would we know that they are?
There are companies, service providers, firms, debt collection companies who have their own market repute. So you need to run and know about their market repute. And ideally, honestly, I would say, please go to a good company and not a company that does not have a particular repute to represent you where you've already suffered.
No problem. We've gone overtime now, and so Benish should probably bill us for this overtime, being a lawyer. Super useful, super helpful, and the advice that you've given, Benish. So thank you very much. We will be recording. We have been recording the session, and we will be sharing it to everyone. We'll also be posting it on YouTube as well. Obviously, disclaimer is, any legal advice, you need to reach out to a lawyer. This is just generic advice. And obviously, feel free to reach out to Anish. As you can tell, she's very, very knowledgeable in this field, and I'm sure she can help you and your individual circumstances. Yeah, thank you very much.
Thank you very much, Rehan, for giving this opportunity.
Thanks, Benish. Thank you so much.
Thank
Take
you.
care, guys.
Thank you to everyone who
Thank you so much.
Thank you.